tell me I'm going to record now. You need to give me permission.
Okay, I just have. Okay.
Okay. You ready?
We ready. Thanks, Kevin.
Amen.
והערב נענה להנה את דברי תורתך לפינו ופני עמך בית ישראל. ונהיה אנחנו וצאצאינו וצאצאי עמך בית ישראל, כולנו יודעי שמך ולומדי תורתך לשמה. ברוך אתה אדוני המלמד תורה לעמו ישראל.
Amen.
ברוך אתה אדוני מחלם אשר בכוונה מכל העמים ולנתן לנו את תורתו. ברוך אתה אדוני נותן התורה.
Amen. Thank you, Jeff.
That's it. Okay.
That's it. Okay. So, firstly, everybody, thank you very much for the longer session on Friday. Sorry, on Thursday. I apologize. But we did a proper daf, the 10th daf. We're just doing a review on 10b4 in terms of where we ended off. So where we ended off was very straightforwardly that Rav Kahana said to Rav, which was a great question, why do we need those 3 scriptural verses that the carcass belongs to the damaged party and the damager only has to pay the balance between the living animal and the dead animal? When in fact, what could happen is from the verse, he shall return money, where you can pay an article worth money, such as bran, etc. He has to give him the carcass back. He can pay him with anything he wants. So why do you need to go through these 3 verses when you can just give him the carcass back, the person you injured, and then pay him the balance of the money for what that animal was worth alive? And it's a good question. The Gemara has to revise its understanding. And it says the scriptural teaching that is it's the owner that must deal with the carcass is needed only to resolve the issue of carcass's depreciation. So that's how it ends off. And what we said is that there were 2 factors. The first factor is that if an animal is injured, this is according to Tosfot, right? Yeah. That there's a certain period of time, and what's going to happen is when we hit Bava Kamma 34a, it's going to go through the procedure of what's involved with a animal that's injured. So why do you wait a certain period of time? Because one of 2 things will happen. Either the animal will start to recover somewhat from its injuries, and then you're not having to, as a damager, pay for a wound that could render the animal, for example, incapacitated, where in a natural course of however long, the animal would be fully functional, so it doesn't hurt the damager. And it doesn't hurt the injured party because the animal, sometimes there are injuries like brain traumas and other sort of injuries which the animal can die 3 or 4 days later or be severely impaired. So that only can be determined after a period of time. So we're going to see what period of time they wait according to what injury. And so Tosfot said that the animal's condition has to be assessed at the time of trial. But it's completely the opposite, Rashi said, when it comes to an animal that's dead. Why? Because the minute the animal is dead, rigor mortis sets in and there's decaying of flesh. So you want to get the animal to the base din to assessment as soon as possible. Because the longer you wait, whether the damager or the damaged party pays for the what do you call it, the decaying part of the animal's flesh, the reality is somebody's paying. So the court has to make sure that this is done timelessly. So as long as you get it to court, from what I did, my research, the court doesn't really keep you waiting. It's not like a South African court or a normal trial, because they're not trying to determine guilt or innocence. At that point, I think there's a separate section where they're just doing appraisals. Now, why does the court have to do appraisals? Why do you think, guys, as opposed to, in other words, for example, if we say it's the damaged party's issue, why can't the damaged party just take it to the non-kosher butchery? Why non-kosher? Because we said the animal wasn't shechted. It was died by being perforated or whatever case might be in impact. So it gets taken to a non-kosher butchery. They pay you for it, and then you tell the damager what you owe in terms of balance. Why does it have to go to the base din for assessment of the carcass? Why do you think?
It's a very good question. And when I was reading it, I was also thinking, why don't they take it to the market? Because if you take it to the market, that's the actual true value.
Correct.
So how's the bet then? I mean, what does the bet then have? Do they have a butchery, like a guy who understands meat properly to assess it? Because the best value for that, if you want to appraise something, the best value is the market value that you actually get for it.
Correct. So there's a reason, and it's something I thought of, and I can't bring proof for it. Human nature being what it is that people take advantages of situations. What do they do? Say for an insurance policy, they charge you a 2.5 or 3,000 Rand excess, or they'll charge me a 5 to 7 grand excess. What you generally do is approach the panel beater and say, listen, the other oak hit me. Can you work it into the price? And then you think, okay, I'm guilty. Maybe I have to find out from a rabbi if I'm actually allowed to ask such a question. You know, because you say to the panel beater, listen, I can give it to you or another panel beater. The insurance policy is making me pay that balance. You want to fix the car, work it in. And then you think, hang on, halachically I'm allowed to ask that. But what do you think is going to happen with an animal? Somebody's going to do one worse. They're going to reason in their head and turn around and say, listen, this guy's cost me time to schlep the carcass. He's cost me time for loss of depreciation of decaying flesh. He's cost me a lot more aggravation. So what does a slightly jaded person do? He turns around and says to the butcher, listen, I can sell this to 5 non-kosher butchers. I'll sell it to you, but give me a appraisal worth less, and give me the balance in cash, and give me a written check for the certain amount. Meaning the carcass is worth 7,000 Rand. Give me 5,000 Rand on the books. Give me 2,000 Rand cash. I'm a bit short of cash flow. In fact, I tell you what, I'll give it to you at least. It's worth 7. I'll give it to you at 6. You're gaining 1,000. Give me 1,000 in cash. Put 5 grand on the books, and I'm seeing that extra 1,000 is maybe paying for the schlep work of the transportation and the slight decay. In other words, in my mind, I've rationalized it as a damaged party. I don't think I'm a Rosha, or I'm saying, listen, Oaks aggravated me, has cost me. So in other words, your Yetzirah is working overtime to get you a better deal. Now the damage is being shafted. Why is the damager being shafted? Because he's having to pay the balance and not the true value. So you need a third party to appraise it, where they can actually have somebody that either like an assessor that goes to the butcheries and deals with the non-kosher butcheries all the time. The Beis Din might have their own non-kosher butcheries, like a conglomerate that they deal with. It might not have been one person. And they might say, well, what is the value of this car? Because just to prevent shenanigans. It's just in my cup I'm thinking this, but I've got no basis for it. I don't know what you guys think of what I'm saying.
Now, I think you're spot on for this generation, but you're thinking that and you're spot on probably as well, but I'm just saying in that generation, you think that type of thing wouldn't happen, but obviously it did.
But then we wouldn't be learning Bava Kamma in that generation either.
No, correct. I agree with you. So this goes back to right back to the beginning. This was a problem.
Yeah, it goes back to the very, very beginning. So
it's human nature. People don't change.
Correct. So I'm not saying my reason is right, but I think
it's a very good reason.
Is they want to make sure that the damaged party doesn't get the damager doesn't get taken advantage by the damaged party. All right. So now that we've understood this, it would seem after my research that there's not a trial date set. In other words, even if the trial to determine culpability is made afterwards, the assessment is done in a separate section, meaning it's not part of the trial, because this sort of damage was going on all the time. Does that make sense in terms of disputes, etc.? And a trial, in terms of culpability, you'd wait for witnesses. In the meantime, there's depreciation. So the first thing they want to do is get it to Beis Din, off to an assessment, and then hold it at that value. Right. So the Gemara asks, shall we say that the question of who absorbs the carcass as depreciation is actually the subject of a dispute between the Tanaim? For it was taught in a brisa, scripture states, if it shall be torn to death, he shall produce a witness. And we're going on to 11a1. Okay, so what does this mean? It means that the paid custodian shall produce a witness that the animal in his care was torn to death in an avoidable mishap, and he shall not be liable for damages. So what this means is, remember that case where the paid custodian was looking after sheep. Say he was a shepherd, and a wolf came and tore the animal to death in an unavoidable mishap, and there wasn't negligence. He would have to provide a witness for it, otherwise he's responsible for repayment to his owner. because he didn't look after the animal properly. Right. Then all of a sudden it brings a completely different discussion. It says, this is the opinion of the Tana Kamma. Okay, so far we understand that the Tana Kamma says that you need a witness. All of a sudden, you have Abba Shaul who says, the verse means the custodian shall bring the carcass to court for an appraisal immediately upon the animal's demise. So that's proof that it's immediate. But how can you go from talking about a witness to exonerate the paid custodian to Abba Shaul talking about the custodian shall bring the carcass to court for immediate appraisal? What do the two have to do with each other? Does anybody know? Guys?
Just repeat that.
Okay, so Abba Shaul is now talking about, firstly, there's a Tana Kamma. So the Tana Kamma is the first opinion of the Mishnah, okay? And that's an anonymous opinion generally. And that's saying that the paid custodian has to produce a witness that the animal was torn to death in an unavoidable mishap. In other words, he wasn't negligent. Otherwise, he'd have to pay for the damages. Gav, are you with me? We did revision on Shabbos.
Yeah.
So Abba Shaul was turning around now and all of a sudden talking about the custodian should bring the carcass to court for an appraisal immediately about the animal's demise. So it seems like these two topics almost have nothing to do with each other. Does that make sense?
They can't be talking about the same case then.
They are. But there is a link that you're missing in English. So the link is as follows, is that, do you remember before with Rav Kahuna that he interpreted aid, witness as ad, until? Kevin, you remember you told us the definition of the word ad means until. The Tana Kamma, not the Tana, Rav Kahana. Do you remember that? So Rav Kahana before said you pay until the value of the living animal. So that's one of the proofs. Do you remember that, Gav?
Yeah.
So I'm saying he interprets aid, that witness case of as ad, until. So you pay until the value of living, meaning that the damaged party gets the carcass and the damager has to pay the difference between the dead animal and the living. So that's how Rav Kahana interprets it. Abba Shaul,
that's if there's no witness.
He doesn't he interprets it obviously that it means a witness. They're not arguing as far as that's concerned. Because the halacha is, if the paid custodian cannot produce a witness, in terms of the fact that it was an unavoidable mishap, he has to pay for negligence. That's the default position. But what Rav Kahana is trying to say is that word alludes that he must pay until, once he gets the carcass, the damager must pay until the value of the living animal. That's what is alluded to with the word. It's not disputing the halacha. Guys, I feel everybody's lost.
No, it's fine. No, it is the same case. I get it. Sorry, I forgot. If there's no witness, he's responsible.
Fine. So Abba Shaul is interpreting the word, instead of ad being witness, is interpreting also as the word adudah. Does anybody know what adudah means? Guys?
No, I've heard it. No, I remember.
It's actually in Bereshit, chapter 49, verse 27. And it says, in the morning he will devour prey, and in the evening he will distribute spoils. So the carcass that is devoured is actually referred to as an adudah. Okay. Even Onkelos brings that. This is in Numbers chapter 31, 11 to 12. It's seen many times throughout Chumash that adudah means carcass. So he says ad, and adudah, or adaa, as Onkelos says it, is meaning carcass. So what does this come to imply? That that at the end of the day, the shepherd that was paid has to, if this carcass gets damaged, it has to be taken to the base den for immediate assessment. So that's how he's interpreting it. So they actually are linked. They're not two completely separate verses. They're using the same biblical source. So what's the point of contention, guys? Is it not that they argue on this? That one master, Abba Shaul, holds that the carcass's depreciation is the damaged party's loss. Okay? Because what it's saying here is that the owner of the farm has to schlep the animal to Beis Din for assessment, okay? But the other master, the Tana Kamma, holds that it's the damages loss. Does that make sense? That the damager has to schlep it. So that's what they're asking. Is that the issue? And the Gemara says, no, listen, this is not the issue. Because why? Both the Tana Kamma and Abba Shaul agree that everybody holds that the carcass's depreciation is the damaged party's loss. I'm going to explain to you why. What they're arguing about is who incurs the trouble of transporting the carcass from the accident site to the court. So why is it the damaged party's loss? Because it doesn't matter if the damaged party or the damager transports it to the Beis Din for assessment. The carcass is depreciating either way. And while it's depreciating, who's losing out? The damaged party. Does that make sense?
So I would say that the damaged party must take it as quickly as possible because they can't rely on the damager to take it.
Correct. That's actually the bone of contention, that the damaged party does pay either way, but Abba Shaul is basically saying that the custodian must bring the carcass, and the Tana, because the custodian is the one that's actually the person that's going to lose out. Why? He's the one that's paying. He's the one that is the damager. I get what you're saying, Gavin. So what you
we've agreed that we're talking about damager and injured party. Fine.
That's fine. No, that's not what I'm saying, Michael, because in this case, the custodian is the damager. Because of his negligence, he failed to watch the animal. What I'm trying to determine here is why Abba Shaul says that the custodian, who's the damager, because of his negligence, shall bring the carcass to court. Because according to what Gavin's saying, it does make sense that the damaged party take it to court because it's in his interest to do so quickly. Whereas the damager might take his time because he's not incurring the loss.
Isn't there a proximity issue? I mean, the guy could be, the damager could be, using the ox on his own land. Okay, you say they were close to each other, but considering where the accident happens and the injured party is not there, shouldn't make sense that the damager gets it to the Beis Din as quickly as possible.
Okay, so that's also a good point. So the good point, what Michael's trying to say is maybe this guy owns a lot of different farmland and he's not there. And the paid custodian who was there, he's right there by the animal. It's going to be more expedient for him to get it from the accident site to the court as quickly as possible. So it's going to unfold now. So let's just go through both Michael and Gavin's example, because both of you have got good points. So the Gemara uses support for the new interpretation. So this is what it says. When it uses the term others say, it's talking about other rabbonim. Others say, from where do we derive that it's incumbent upon the owner of the pit to raise the dead ox from its pit? So it's taking this particular case of a classic damager. Because remember, there was Rav Oshaya and Rav Chista that brought other damages. And Rav Oshaya brought the ones of the custodian. Do you remember? The paid custodian, the unpaid, the borrower, the renter. But the classic case in the Mishnah is the pit. The pit is one of the examples. So we're using a classic case. So it's incumbent upon the owner of the pit to raise the dead ox from the pit. So scripture teaches shall return money to the animal's owner and the carcass. Okay, so if we have a look at the full verse, what does it say? The owner of the pit shall make restitution. He shall return money to its owner and the carcass shall be his. So the Rashi is basically understanding the word carcass to be the second object of the verb return. In other words, when he's returning the carcass to the damaged party, he's not only returning it for financial restitution, he's physically returning it to him as quickly as possible. Therefore, the damager has the duty to deliver the carcass to the injured party. Does that make sense, according to the straight interpretation of the verse?
It does.
Okay, cool.
Yeah.
Okay. All right. So let me just check one thing. All right. So that's found in Shmot chapter 21, verse 34. Okay. So after it's been raised at the bottom of the pit, there is a problem, which one of you guys mentioned. Abaya said to Rava, what is the case of incurring the trouble of transporting the carcass? If we say that the pit, in the pit, the carcass is worth a zuz, while at the edge of the pit it's worth 4 zuzim, then while the damager troubles himself to remove the carcass from the pit and bring it to its owner, he troubles himself for his own benefit. Why then must Scripture formally obligate him to transport the carcass from the accident site? Okay? So what it's saying is here, since the damager's liability is reduced by the appraisal of the carcass, it behooves him to raise the carcass and thereby enhance its value. That's according to Rashi. In other words, basically, if it costs him, let's just use the example of the pit, because now we're not talking about a depreciation issue. The depreciation issue is for the damaged party always. But what we're saying is that he has to pay, if he can't produce a carcass, because the carcass is seen as a deposit, and he's granted a mercy by the court that he can pay the balance of the money owing from between the animal's value at death compared to what the animal's worth alive as a balance. But therefore, the carcass forms a deposit. So therefore, if he doesn't produce the carcass as a deposit to pay the injured party, he owes the entire amount in cash or land. Does that make sense, guys? So therefore, it's the damager's interest to deliver the carcass. Otherwise, he's going to have to pay the full amount in cash. He's not going to have the mercy of being able to use the carcass as a deposit collateral. So that makes sense. So what actually is the question is, we don't understand why a buyer would say to, we understand why a buyer would say this to Rava, but he's saying, well, why would you need the brisa to tell you that he shall, that the damager shall return money to the animal's owner and the carcass? Because obviously he has to make financial restitution. And obviously implied by the word returning the carcass means it's his job to schlep it out, because it's in his financial interest to do so. So why even have the question? Do any of you know the answer before I go on?
I sort of an idea about what you were talking earlier, just to add to it, because I was listening. I listened to one of the shiur and I read through it. I don't know if I'm correct, but trying to put this into a way, he doesn't. You don't take the whole carcass to the guy. You got to take the collar, just the collar as well, to the actual what's name is good enough. They said. No,
what you're thinking is one of the rules. Just hang on. Of Rav Ulla said in the name of Rav Eliezer. It's one of these 7 things Rav Ulla. That has nothing to do with it. That has to do with property acquisition.
Okay, my mistake there. Okay, and the other one is maybe when you. Okay, so while maybe about the thing where you take the carcass out yourself is because let's say the carcass was with one zuz at the bottom, right? And it cost you 4 zuz to bring it out. Okay, whether it's at the bottom, at the bottom it's still 1 zuz, but technically still with 1 zuz at the top. So it's in your benefit to take the carcass out yourself.
Okay, let me say it in a way that makes sense to everybody. I know what you're getting at. Let's just put it in English. Guys, it's stuck at the bottom of the pit. Now, it's assessed at the bottom of the pit at 1 zuz. Why? Because a rigging company still has to drag the animal up. Are you with me? So the rigging company says, I'm going to give you 1 zuz for it if you leave it at the bottom of the pit. And here's your cash, and then you pay all the rest to the injured party. Fine, the person you damaged, because it's his ox. So you're only going to get 1 zuz at the bottom of the pit. But if you drag it out to the edge of the pit, that animal itself is worth 4 zuz. And when you take it to Beis Din, you've actually saved 3 zuz in cash. Now, it's not worth it if the guys that are rigging the animal up are charging you 3 zuz. Why is it not worth it? Because you might as well not schlep them. Does that make sense? You've not made any financial gain. So we're talking of a case where they would charge you maybe a zuz to pull it out, and it's worth a zuz at the bottom of the pit. So you're still scoring 2 zuz. So that's why the damager troubles himself by removing it from the pit. Now, don't think of it zuz as like 2 rand. Think of it like maybe like 2,000 rand. Do you get what I'm saying? A zuz might be 1,000 rand or 10,000 rand each. So just because it's a lower amount, don't think of it in terms of low value. Does that make sense? So I'm saying it's not going to cost him 3 zuz to pull it out the pit. It's worth a zuz in the pit. He'll get paid by a rigging crew, which they'll say, here, take the animal foots, toots, and the guy says, here's a zuz. But he's losing 3 zuz. If he pays the rigging company to pull him out, or he gets his own guys, he could probably get it done for another zuz. So he's scored 2 zuz. So it pays him to pull it out of the accident site.
Himself.
Fine.
Okay.
Now, Rav has said back to a buyer, there is no difficulty. For in the pit, the carcass is worth a zuz, and at the edge of the pit is worth a zuz as well. Hence, the damages does not reduce his liability by raising the carcass. That's why you need the verse, he shall return the carcass, because it's a biblical requirement to return it to the injured or damaged party. You get what I'm saying? So how could it be worth a zuz at the bottom and zuz at the top? Let me tell you a practical example of how it could be worth a zuz. Let's look at it in terms of profit, guys. It's costing you a zuz at the bottom. Some oak's going to pay you a zuz to get it. It's going to cost you, you're going to be worth 4 zuz when you bring it out. But the transport has cost you 3 zuz. So if not the transport, what do you call it? When the guys rig it up or whatever. When they schlep it up. You know, hoisting equipment, whatever, it's costing. So you haven't made any money. So you figure, why bother? And the reason why you bother is that there's a biblical law that you shall return the carcass whether you want to or not. In other words, whether you're saving money or not, you need to return it as payment to the damaged party. And the reason being is it's an absolute sin to let an animal that could be feeding people, even if you're not making money out of it, be just deteriorating at the bottom of a pit. It's just a pointless exercise. So even if you're not making, there should be some sort of economic productivity. Am I making sense to you guys?
100%.
Yeah, but you could actually run at a loss here, eh?
Well, then you should have watched your pit.
Yeah, I'm just saying. 100%.
All right.
But you can end up losing a zuz because of this.
Of course, you shouldn't create
the transport cost and everything.
Yes. All right, let's just cover one thing quickly.
All those costs can exceed the value of the carcass. That's the problem.
Yes, absolutely. But then you should wake up and not create public damage. So
100%.
the Gemara answers. All right, so what about the transportation? We've discussed schlepping it out of a pit. Now let's talk about transportation. So they're saying, listen, a beam, but is there such a thing as this? Because making an object more accessible, doesn't it increase its value? Let me give you an example. You're in an agricultural forest. So they're saying that a wooden beam in the forest is worth a zuz, but then in the town, it should be worth maybe 4 zuz. Why? Because it costs transportation to get it out there to the town, right? And it's not easily accessible. So once it's in the city, it's normally the price is jacked up because of the cost of transportation, storage, logistics, etc. But they're saying something doesn't make sense because it says people say that a beam in town is sold for a zuz and the beam is in the field is worth a zuz. Because either the beam in the field should be worth less or the beam in a city should be worth more, because either you're paying less logistical cost or more. But we can see an example today, and I thought about it. If you go to, let's say we go to Pick and Pay, and you go to Pick and Pay in the Mams and Toti where my dad lives. People there earn very little money in the Mams and Toti unless you've got your own business. Salaries at the coast is worth low. The property prices are the same. And what you buy at Pick and Pay is the same as what you buy in Santon. There's no difference in you buying goods in Pick and Pay in Soweto, in White City. I've been to White City in Soweto. I don't know why they called it White City. It was the only white person there. But anyway, I went to the Pick and Pay there. I got something, and I paid the same amount as what it cost me at Killarney Mall. The prices are set. And in other words, the refracting cost of logistics is distributed amongst many branches. So we do see a case like that today. So the Gemara is saying, even in the case where you're not schlepping it out of a pit, and there's logistical cost, sometimes branches have homogeneous costs. Does that make sense? So you still have to spend the money to make sure it's done. So our law is to discuss whether the damager pays for the schlepping or the damaged party. So that's what we have to discuss. Arthur, how long do we have left?
5 minutes and 21 seconds.
Okay, great. All right, guys, so it appears from everything we've read up until now, who pays for it? It seems to be the damager.
Mm-hmm.
Does that make sense? All right. So the Gemara now discusses the law of evaluating a carcass applying to other damages. So Shmuel said the courts do not evaluate for either a thief or a robber. Because if an animal was stolen by them, dies in their possession, they must keep the carcass and pay for the animal in full. So I just want to explain to you the halachic source. It's in Leviticus chapter 5, verse 23, where it says, he shall return the loot that he robbed, which teaches that a thief or a robber, he must either return the item that he stole or pay its value in money. Does that make sense? That's according to Tosfot. So Shmuel taught that judges require a thief or robber to replace the item or animal that he stole with a new one if the animal died or the item was broken in his possession. The thief cannot return the carcass or broken pieces of the item and then pay the difference in value between them and the item that he stole. This is according to Rashi. Why? Because a thief is a breaker of the law. He's a criminal. If somebody creates a hazard, okay, they've done wrong, they have to pay, but they're not a criminal, they're negligent. But a thief and a robber is not accorded the same sort of mercy. Does that make sense, guys? In other words, he can keep and have to schlep about selling the carcass and go through the hassle, and he must pay the owner either the living animal or a brand new article. So then there's a question that's asked. They only evaluate a carcass in terms of the damages. Fine. And Shmuel says, and I say this is true of a borrower as well, and Abba agrees with me in this. So at first the Gemara says we don't know what this means. We don't know if Shmuel and Abba agree with the fact that a borrower works like a thief or a robber. In other words, if he damages the car that he borrowed, he has to replace the car, or he just has to fix the car. I think a better example is an animal, because a car, nobody would say you have to buy a person a new car, but an animal that you get to work, you've worked it. It's not a case where it dies in its normal use. Do you remember that? Because when an animal dies in its normal use, it's like a car where if somebody borrowed your car and you blow a head gasket. Now that damage was long coming. You can't expect the person that borrowed your car to replace the head gasket. It's only if he was flooring the car in a drag race that is responsible for that sort of damage, for abuse. So they're saying in the case where the borrower abused it, in that particular case, does he fall within the category of a damager, where he has to basically just pay the difference between the damaged article and the cash equivalent, or does he have to replace the article? Or does it work in the case of a robber or thief where he has to replace the article entirely? Does that make sense?
Yeah.
All right. So what it's doing here, okay. So what it's saying is the Gemara seeks to clarify Shmuel's ruling. They inquired, is this what Shmuel meant to say? That in the case of a borrower as well, do we evaluate? And Abba agrees with me in this. Or perhaps what Shmuel meant to say is, I say that for a borrower as well, we do not evaluate, like in the case of a robber or a thief, and Abba agrees with me in this. So the Gemara is not sure. because the statement seems a little bit vague. So the Gemara is going to attempt a proof. It says, come learn from a proof the following incident. There was a certain man who borrowed an axe from his friend, and he broke the axe negligently. He came before Rav for a ruling, and Rav said to the borrower, go and compensate the owner with a good axe and keep the pieces for yourself. We can derive from this ruling that Shmuel ruled that we do not evaluate for a borrower, meaning that a borrower is treated like a thief or a robber. Because if we evaluate, we would say the pieces, a new axe is 100 shekels, this broken axe is worth 75, you must make restitution of the balance of the 25 shekels in order to have the axe fixed. So it would seem on the surface that that's the case.